Good morning and welcome. Is this on? Oh, good. Good morning and welcome. I'm Tom Leonard. I'm Senior Fellow and as of recently President Emeritus of the Technology Policy Institute, and it's a pleasure to welcome you all here to our discussion of the FTC's recently released and I think it's fair to say eagerly anticipated report on patent assertion entities. PAEs have been a controversial part of the patent landscape for quite a while now because of concerns that they're the source of excessive and wasteful litigation, sometimes involving patents of dubious value, and that all of this adversely affects innovation. And indeed, the ink was barely dry on the American Invents Act when people started proposing new legislation to address concerns about excessive patent litigation, with the poster child for that being PAEs. On the other hand, there is research that finds that the litigation statistics properly interpreted do not indicate that PAEs should be singled out. And moreover, PAEs clearly have a potentially important economic role to play. They can contribute to more efficient secondary markets, increase liquidity, help inventors and other patent holders negotiate, license, and assert their patents, all of which can have a positive effect on the market for new innovations. The FTC has been active in patent issues for many years, producing numerous reports and workshops. In 2012, the Commission held a workshop on PAEs featuring industry and academic experts, and that workshop was a precursor to the current report, whose intent is to fill some important gaps in the information about PAEs and how they operate. We are privileged to have a really good program today, great panelists, and a great keynote speaker to open the session. Our keynote speaker is FTC Commissioner Maureen Ohlhausen, who has been on the Commission since 2012. Before that, she was a partner at Wilkinson Barker Knauer, and prior to that, she served in various positions at the FTC for 11 years, ending as director of the Office of Policy Planning from 2004 to 2008. So she has a great depth and breadth of knowledge on all issues having to do with the FTC, and it's a privilege to have Maureen here.
Well, good morning, everyone. And Tom, thank you for that kind introduction. The FTC's PAE report is an important milestone. It embraces evidence-based analysis and moves away from the casual denunciation that I think had too often characterized prior debates in this area. The report advances our understanding of patent assertion entities and their role within the patent system. And perhaps it will help us appreciate how PAEs may affect the larger innovation environment. TPI has assembled an exceptional panel to address the report and the proper conclusions to draw from it. And in my opening remarks this morning, I hope to contextualize the report by addressing the background economic conditions that underlie technology licensing markets and that drive the business of patent aggregation and licensing. I will also touch upon the report's most significant findings and recommendations, though I'll leave the finer details to the distinguished panelists gathered before you. Finally, as the FTC report covers a period from 2009 to 2014, and because the last 2 years have been especially eventful on the patent front, I'll also mention developments relevant to PAEs and patent holders more generally since 2014. But as I address these points, please remember my views are just my own and not necessarily those of the Commission. So PAEs are part of the larger patent system, and patents give their owners exclusive rights to practice the claimed technologies. As property rights, patents can be sold and licensed. And their justification, as recognized by the Constitution, is to spur innovation. Innovation varies by industry from a continual process of incremental improvement over the status quo, as in the software industry, to revolutionary and sporadic and unpredictable leaps forward as occur from time to time with blockbuster drugs. To monetize their discoveries, inventors must commercialize their technologies by developing them to the point of marketability. And patents can induce firms to devote the private capital necessary to bring cutting-edge technologies to consumers. Some people and entities have expertise in inventing early-stage technologies, and then others may be better placed to develop them into sellable products. And patent rights allow an efficient transfer of ownership. Now, it's important to note that whether the original assignee, that is the inventor, is a practicing or non-practicing entity is irrelevant to the efficiency of ex-ante patent licensing. Now, unfortunately, the reality of technology licensing in many industries is more complicated. Just as the Coase theorem ceases to apply when transaction costs rise to prohibitive levels, so technology transfer struggles to occur when it becomes difficult for owners and users of technology to find each other. So having reviewed the empirical literature on the subject, I am sure that strong patent rights are an integral part of our successful innovation platform. But that doesn't mean that today's patent system is ideal in all respects. As electronic goods incorporate an increasingly large number of discrete technologies, manufacturers must obtain rights to an ever greater number of patents to avoid infringement. When ownership of those rights are disaggregated, two problems result. First, royalty stacking effects may lead owners of technologies that must be combined in end products to charge more than the optimal price. Second, as the number of patentees with whom a technology user must secure licenses increases, so do the search, identification, and bargaining costs. Compounding that phenomenon is a long-expressed concern with software patents, which claim methods for achieving a particular goal using a computer. As a result of such conditions, whether real or perceived, many technology firms decide to press ahead in building products without securing the necessary permissions first, depriving patentees of compensation in the first instance. And when patent licensing negotiations do arise, they often do so in ex post, that is, after an infringer is selling the accused product. As the FTC explained in 2011, ex post patent licensing raises tricky issues that differ from ex ante technology transfer. But whether ex post licensing is a good or bad thing depends on questions to which we lack answers. If most accused infringers independently invented the technologies that they adopt in their goods, that raises different issues than if they copied them from patentees. If ex post licensing takes place over a probably invalid or not infringed patent, then patent assertion may begin to resemble attacks on innovation. By contrast, if a firm owns valid infringed patents and sues companies that deliberately ignored its exclusive rights, then the ensuing ex post patent license is appropriate and beneficial. We can't also ignore efforts by technology users to avoid paying patentees or to delay doing so for as long as possible. Now, several market realities can limit ex post patent licensing. Technology firms are slow to sue one another because doing so invites a countersuit. And patent litigation is expensive, particularly in the discovery phase. Hence, most patents remain unenforced ex post. Now, the reality that I've described in the last few minutes is messy and flawed, and there was, and perhaps still is, a disconnect between upstream inventors and the downstream manufacturers that sell technological products to consumers. Now, if an intermediary were to emerge that efficiently bridged the gap between patentees and technology users, it could bring new solutions and functionality to manufacturers while rewarding patentees and encouraging further innovation. It is in that murky space that patent assertion entities arose. PAEs buy and aggregate patents under threat of suit. They do not invent or manufacture technologies. They seek to license these patent portfolios to entities that manufacture or use the patented technology. And their business model is, in many respects, a function of today's patent system, a natural consequence rather than a cause. Because they do not practice their technologies, PAEs are not vulnerable to infringement counterclaims. And further, by specializing in patent assertion, PAEs may realize scale economies in litigation. And because they do not invent technologies, their discovery costs may be much less than those of the manufacturing firms they sue. In short, they may be efficient patent monetization vehicles. The economic effects of PAEs turn on several factors. Do they amass valid infringed patents or weak ones? Do they license their technology on the merits or secure revenues based on credible threats of nuisance litigation? Are they effective intermediaries, channeling licensing revenues from downstream users to upstream inventors? Do they facilitate liquid and transparent licensing markets, or do they create bottleneck licensing positions, siphoning off much revenue for themselves and sharing little or none with original inventors? And in identifying patents for acquisition, do they seek the highest quality intellectual property rights or abstract ones suitable for broad assertions of infringement? Those subtleties largely escaped attention when PAEs began to emerge as significant players in patent markets roughly a decade ago. For technology users accused of infringement, PAEs were high-tech extortionists. For PAEs, however, their business model creates an otherwise absent market for inventors who lack the capital to monetize their patent holdings. Now, the anti-PAE crowd waged an extensive battle in the court of public opinion, and I don't have time here to address the full array of commentary, but I'll touch on one notable example. In 2013, President Obama opined that PAEs, quote, don't actually produce anything themselves. They're just trying to essentially leverage and hijack somebody else's idea and see if they can extort some money out of them, end quote. And arguably, the single greatest blow to PAEs was self-inflicted when MPHJ Technologies sent demand letters to over 16,000 small business owners, and the FTC eventually intervened to protect consumers in that instance. So this brings me to 2013. So while some PAE activities gave me pause, the frenzied reaction within the technology industry, academic community, executive branch, and even on the Hill worried me. The new economy is rapidly evolving, exposing the patent system to new challenges. In our market system, private ordering solutions to emerging problems are to be expected, and we should exercise caution before condemning new business models before fully understanding them. And this is but one application of my larger philosophy of regulatory humility, by which we appreciate the limits of our knowledge and act with due regard for the cost of erroneous intervention. And that factor weighs quite heavily with respect to the patent system, which has long been a central pillar of America's innovation platform. Hence, in December 2013, I gave a speech in London counseling caution before making any sweeping changes and urging an evidence-based approach by taking steps to understand whether there is a problem with PAEs, and if so, the nature and scope of the problem. And I noted patent reform bills under consideration in Congress, including the Innovation Act, the Saving High-Tech Innovators from Egregious Legal Disputes, or SHIELD Act, the Patent Litigation and Innovation Act, the Patent Abuse Reduction Act, the Patent Quality Improvement Act, the End of Anonymous Patent Act, and the Patent Transparency and Improvement Act. Now, the sheer number of competing bills are telling. They reflect the perceived urgency at the time to do something about abusive patent litigation. Now, some of the bills had some sensible provisions, such as recording the real parties in interest, but many of them would have brought potentially disruptive changes to the patent system, like cost shifting. And those effects would reach beyond PAEs to affect the full universe of patent holders. And no less importantly, it was unclear to me that a dispassionate review of the evidence revealed that PAEs were unambiguously harming innovation. Observing the limited empirical work to date, I noted the mixed and incomplete evidence on the economic effects of PAE activity and on the causes of the recent surge in patent litigation. And while PAE conduct may raise some troubling issues, I commented that PAEs offer a means for small companies and individual inventors to more efficiently protect and monetize their inventions. For those reasons and more, I explained the need for caution and, above all, facts before embarking on wholesale changes to patent law. The cost of erroneous intervention could do more harm than good by chilling legitimate infringement litigation and diminishing the basket of rights that have successfully fueled our innovative economy for so many years. Hence, I embraced the FTC's study on PAEs, which had only recently been announced. So here we are, almost 3 years later, with the report hot off the press. And I must begin by commending staff, including Suzanne Monk, who's on this panel, for their dedicated work. Their painstaking empirical analysis has paid dividends. But I first want to make clear what the report does not do. First, it takes no position on the efficiency of PAE business models. A key issue in normatively analyzing PAE conduct is to calculate how much revenue travels to upstream inventors. Due to data limitations, FTC staff could not reliably calculate revenue sharing consistently across PAEs in the study. Hence, although some commentators may try to suggest otherwise, the report does not in itself show that patent aggregation and licensing by PAEs harm social welfare. Second, the report is a case study, not a statistical sampling that tests hypotheses about the full universe of PAEs. Now, no doubt the panelists today and many other commentators will discuss the conclusions that we can reliably extrapolate from the data about PAEs more generally. The FTC's efforts to include both the most economically important PAEs and ones of various sizes produced a universe of 22 study PAEs and over 2,500 related entities. Those study PAEs accounted for over 75% of all US patents that PAEs held at the end of 2013. Now, perhaps the result is sufficiently representative that we can at least discuss inferences about other PAEs. In any event, the FTC report discloses a variety of fascinating information about the study PAEs, which makes for interesting reading in its own right. Now, as for its substantive findings, the report was worth the wait. For me, the standout conclusion was that there is no one PAE business model. Rather, a glaring distinction exists between portfolio PAEs on the one hand and litigation PAEs on the other. Portfolio PAEs appear to be sophisticated firms that aggregate hundreds or thousands of patents, license their portfolios for millions of dollars apiece, and capitalize themselves through institutional investors. Despite making up only 9% of the licenses in the study, they generated 4/5 of the revenue. They hire specialized IP licensing professionals and typically negotiate licenses without first suing their prospective licensees. On average, the patents they acquired were over 3 years younger than those that the litigation PAEs obtained. All told, portfolio PAEs engage in conduct that is potentially consistent with an efficient aggregation service. Given the sums that change hands in arm's-length transactions between portfolio PAEs and their licensees, amounts that well exceed the costs of litigation, it seems that technology users paid sums that may reflect the quality of the licensed patents. Furthermore, in aggregating thousands of presumably related patents into a single source, portfolio PAEs may alleviate royalty stacking effects associated with divided ownership of complementary property rights. Now, of course, it does not necessarily follow that portfolio PAEs enhance social welfare. It's possible, for example, that portfolio PAEs share little revenue with upstream inventors, that many of their patents would not have been asserted but for their accumulation, that their licensees independently invented the claimed technologies, or that their IPR holdings are of poor quality. To be clear, the FTC's report does not ask whether PAEs benefit innovation, but the facts unearthed about the portfolio PAEs in the study reveal complex businesses that at least potentially serve a valuable aggregation function. Thus, the FTC report does not show that portfolio PAE activity harms innovation, and there's no basis to claim otherwise. Some litigation PAEs, by contrast, may be engaging in nuisance litigation. They generally sue technology users without first negotiating, and they settled shortly afterwards. The portfolios that they licensed often comprise no more than a few patents. They generated royalties that were typically less than $300,000, an amount that accused infringers could expect to expend through initial discovery. Despite filing 96% of the lawsuits in the study and representing 91% of licensees, they accounted for only 20% of the reported revenue. Now, there are too many other relevant findings for me to recount in these opening remarks. A few conclusions, however, bear mention. First, demand letter campaigns by PAEs did not, in themselves, produce revenue. Hence, it appears that the MPHJ case may have been an outlier. Second, PAEs largely acquired and licensed software-related patents covering technologies in the information and communications technology industry. Now, of course, those patents, more than most, have come in for criticism on quality grounds. The fact that study PAEs generally focused on software-related patents has policy consequences that I'll address momentarily. Third, despite the prominence of claims surrounding harmful assertion of RAND-encumbered standard essential patents, less than 1% of the patents in the study were declared SEPs with RAND commitments. Finally, the evidence suggests that some PAEs target end users of technologies rather than those that built the infringing devices. Now, while I'll emphasize that patentees can legitimately sue anyone who uses their claimed inventions without permission, parallel litigation against the maker and purchasers of an infringing component can introduce wasted litigation and private costs. And this is especially so when a manufacturer has superior discoverable information about how the accused device operates. In response to these and other findings, the report presented measured, limited recommendations to alleviate potential litigation abuses by PAEs. For instance, the report suggests that Congress passed rules increasing transparency, and it encourages courts to use the tools they already have to stay litigation by PAEs against end users when parallel proceedings are already underway against the manufacturer. I support these proposals because they wouldn't hinder patent holders in enforcing their legitimate rights. And importantly, their limited scope means that they would not have unintended consequences in fields far removed from PAE activity. Now, I look forward to hearing from our distinguished panel momentarily. And as we weigh the PAE report at a policy level, however, consider how the patent environment has changed since the study period closed in mid-September 2014. So I opined in 2013 that to the extent that there is a problem with PAEs, it is likely to be a function of patent quality, particularly with respect to software patents. And the 2016 PAE report is consistent with that proposition, given the prevalence of ICT patents at issue, and that some litigation PAEs apparently use nuisance value lawsuits to extract revenue. But in weighing next steps, we must consider what has already happened. The Supreme Court's 2014 decision in Alice was a watershed moment in patent law, having ramifications that are becoming more apparent by the day. With a couple of notable exceptions, the Federal Circuit has repeatedly found software-related patents directed at abstract concepts to be patent ineligible under Alice. Less than a month ago, in a case by a large PAE, Intellectual Ventures, against Symantec, the court found that the patents at issue to be invalid. In a concurring opinion, Judge Meyer wrote that, quote, claims directed to software implemented on a generic computer are categorically not eligible for patent, end quote. Now, while I disfavor absolutes, it seems that patents claiming computer-implemented methods stand in a precarious position. Other changes have also materialized. In Octane Fitness and Highmark, the Supreme Court made it less difficult for prevailing accused infringers to recoup their attorney's fees and costs. In Nautilus, the court effectively strengthened the definitiveness condition of patentability. In Limelight, it made it harder for patent owners to show induced infringement. In Cuso, earlier this year, it upheld the PTAB's use of the broadest reasonable construction standard in interpreting claims in inter partes review, a broader standard than applies in federal court. And there's even more to come. 9 days ago, the Supreme Court held oral argument in Samsung versus Apple concerning damages for a design patent that applies to only one component of a larger product. And there have been other changes. As the FTC's new report observes, as of December 2015, the minimum pleading standard articulated in Twombly applies to patent cases. And there are signs that 2016 will produce fewer patent cases filed in federal court than in prior years. So last week, for example, Lex Machina found a 12.6% reduction in patent cases over the prior quarter. Given these and other changes already underway, we must ask ourselves an important question. If litigation PAEs create problems, is the solution already underway? If so, further tinkering with the patent system may do more harm than good. And that is why I favor incremental, modest reforms like those identified in the FTC report. So thank you for your attention this morning, and I look forward to your questions.
Thank you, Commissioner. Let me take the prerogative of asking the first question. Do you think this report will, add to, take away from the push towards new legislation or some sort of new patent reform?
What I hope it would do is that it would inform that debate. So previously, for all the bills that I listed, it all kind of came to a big crescendo at late 2013. My concern was that this was happening based on a lot of what I would call anecdata, right? There wasn't real data there. There was concerns and lots of stories, but it wasn't based much in real hard data. There were some reports, some studies, but they had flaws and limitations, I should say. So the question for me is, based on our study, which admittedly is a case study, but I think it was, gave some fairly useful insights. What is the problem? What is the phenomenon that's driving these concerns? A lot of it seems to be asymmetric litigation costs. Then how do we target that? So that's the thing that I hope the report can add to. At the time in 2013, it seemed like let's throw everything, like every possible kind of approach at this and be much, much broader than PAE. So many of these things were aimed at all patents, right? And we don't really have any, I don't have a reason to believe that this is, a much wider problem. So I hope it will make the debate more informed and more focused on doing something to address what seems to be perhaps a litigation problem. Also with the understanding that all these other actors are moving in this space to address some of these other issues like patent quality or software patents or ability to get attorney's fees in certain cases.
Okay, the floor is now open for questions. Yes, if you could, first of all, wait for the microphone. Secondly, identify yourself and any affiliation.
Hi, I'm Stu Shem. I'm Wilson Cincini. I was interested in your comment about not being any evidence whether or not, particularly portfolio PEs, benefit innovation. And I was wondering whether we're able to make any conclusions about whether these PAEs have any type of buyer-side market power. If they don't, then you would assume that some of the revenues would flow back to innovators. And so can you comment on that?
I would say that's not something that the PAE report examined. I do think that's an interesting issue. So your question is, are the portfolio PAEs able to exercise market power over the individual inventors or however they get these patents? I would say I don't really know. Certainly, if there's an antitrust issue there, we might be interested in it, but I don't think we can make any conclusions about that based on our study. And I'm not going to hypothesize otherwise.
Yes, sir.
Thank you. My name is George Willingmeyer. I'm with a Standards Policy Consulting business. I was interested in your quote of the statistic of the PAE study account for just 1%. George Willingmeyer, GTW Associates, interested in standards policy and complimenting your observation about the 1% quote of the PAE study accounting for the number of standards related. Yet there is a reference in the report to a study or a report where if you read it independently, at least I read it independently, you might reach a different conclusion. Oh, this might be a bigger problem. At least that's how I read it. And I'm wondering if you have any further observations about regulatory implications for standards. It's my point of view that if there is a problem where it deserves to be looked at, however, there is a important priority setting, and maybe the priority of standards-related issues is lower compared to some other problem that may exist. So just an open invitation for you to elaborate anything you'd like to about standards.
Well, I mean, standards are a very important part of technology these days, right? There's many standards that many bits of IP that go into a standard. But I do think it's important to have some clarity about, PAE. I mean, so there's sort of like this, I would say, like swirl, right, of all these issues coming together, standard setting and PAEs, so sort of like creating this, concern that, like, boy, there's big problems with the patent system. One thing I would be interested in is in the standard setting space is how much that really is PAEs participating or having IP that's in the standard versus, there's lots of other entities that invent, that hold patents, that don't qualify as PAEs that may participate in standard setting. And so I see those issues as very separate issues. On standard setting, it has a lot to do with, what are the alternatives available in the upstream market when you're choosing what technology would go into the standard, under what what promises were made. Was there a promise not to seek injunctions? What does a FRAND promise mean? Things like that. So I see them as rather, I mean, you may have some of the same players, but they're not all the same players, and I would be hesitant to sort of take anything from our report to have, a big impact on the standard setting issues.
If there's one more question, I think we have time to take it. Otherwise, is there one more question? Otherwise, join me in thanking Commissioner Olhausen again. And if the panel could come up and take their seats, I'd appreciate it. Thanks a lot. Thanks. I'm not sure. I think she's staying for a while. Well, we have a great panel to discuss this, and I've asked each of the panelists to talk to limit their remarks to 10 minutes. You have their bios in front of you. I'll introduce each of them briefly when their turn comes. I've asked Suzanne Monk of the FTC to kick it off. Suzanne is the Chief Counsel for Intellectual Property at the FTC and Deputy Director of its Office of Policy Planning, and she, I think, is the person who led the team that produced the report. So, Suzanne.
Well, thank you you very much. Thank you for including me today. These are also my own views and not necessarily those of the commission or any commissioner. I think that Commissioner Olhausen did a fantastic job of providing a high-level analysis of the report, what the goals were, what our conclusions were, and how you can put the report in a broader context. So I may not take all of my 10 minutes today because I know there's a lot of questions folks will have. And I think Commissioner Olhausen really is the best spokesman on this topic. What I wanted to talk about a little bit was where were we when we decided to start this report? What did we know? We started looking at PAEs following the work that led to our 2011 report. And the 2011 report was looking at the IP marketplace. That was the first time we really started hearing about entities that were buying patents from third parties in order to assert them against folks that were already on the market. So from there in 2012, we said, let's get an understanding of what the harms and efficiencies are of the business model. And I think that's an important point. We had heard about the harms in terms of raised costs. We had heard about the efficiencies in terms of economic specialization. And so we held a full-day workshop together with the Justice Department to better understand these issues. And for me, one thing I thought was striking is that's our normal course. If you look at any of our IP work, we traditionally hold a series of public workshops and then we write a report. But on my industry panel, the first panel in the morning, folks said, you know, we need to have more data. And you said, okay, well, how do you collect that data? And they were talking about the fact that this is a license-heavy environment. So license-heavy environments have non-disclosure agreements. And you need to have a tool to address that. Our 6B authority is in a very good position to address that question because it allows us to compel the production of information for a non-enforcement purpose. We worked with the commission to issue the announcement of the study in September of 2013. Throughout 2014, the commission worked with the Office of Management and Budget and OIRA in terms of balancing the right approach of the data collection versus the information we were going to be able to collect. And that's an important point because if you go back to that time period, you see a lot of folks talking about the burden on industry, and these types of studies require a lot of work from the participants. And we were lucky to have good participation from the folks who were involved in the study, but there is a burden there. So then we moved to 2014, we start collecting the data. We spend a lot of time looking at the information. We have talked a little bit in other fora about the sample selection, and our sample was designed to oversample the most economically important firms, but also include small and medium-sized firms, as Commissioner Olhausen mentioned. One interesting thing here is because the PAE universe is unknown, the FTC's findings cannot be extrapolated to all PAEs operating in the US. However, we think that we've captured some very economically interesting data. As Commissioner Olhausen mentioned, the sample includes an estimated 75% of all US patent holdings. We also collected between 14 and 46% of PAE patent infringement litigation initiated during the study period. The reason that number varies is because we know that we saw about 8.8% of all US patent litigation during that period, and then you have to look to other research of folks who are estimating the total percentage of all US patent litigation that you can attribute to PAEs. So there are various numbers there. I think it's GAO's study that leads you to the 46%. So then what did we see and what's interesting about this? For me, we send out the information requests to a number of PAEs, and we didn't say we're going to send them to 4 portfolio PAEs and 22 litigation PAEs. We just sent them broadly. And as the data starts coming in, as we start reading the license agreements, as we start talking to people and understanding what they've provided us, we see that there are these 2 business models. Again, Commissioner Olhausen did a wonderful job presenting this, so I'm just going to go over this relatively quickly. But the thing to keep in mind is we see a litigation PAE business model. Litigation PAEs acquire a few patents per transaction, take those patents, set up an affiliate, and then use the affiliate to litigate, essentially. That's different than what people have been saying. Was there sort of an aggregation and litigate model, right? What was going on? What's happening once the IP is coming in to the organization. And this is something that nobody else had data on. This is where you kind of hit our non-public side. So you see this sort of thinly capitalized model, setting up affiliates for each transaction, litigating through the affiliate. And that's why, even though we have 22 PAEs that we sent information requests to, we report on more than 300 affiliates. Those are the organizations we're talking about. We also saw the portfolio PAE model. And Commissioner Olhausen also spent a lot of time, sort of discussing this in really good terms, so I don't want to build on that. But the portfolio PAEs were acquiring large amounts of patents or aggregating them into large portfolios and then maintaining them in large portfolios as they were out licensing. Portfolio PAEs were not as reliant on litigation. When they litigated, the litigation tended to last longer. There tended to be more patents involved. It just sort of looks a little bit different. So those are the two models of the litigation PAEs and the portfolio PAEs. And then the other thing we wanted to do was we didn't want to come to you today and say, here are these two business models, and have you say, well, that's great, but what does it look like in the context of the rest of the world, right? So that's why we have the wireless case study. And we chose the wireless chipset industry because we felt that it was relatively well characterized. And we have a second study in the report where we talk about the behavior of PAEs who are litigating wireless chipset patents as it compares to NPEs and manufacturers in the same space. And when I talk about NPEs, those are folks who are developing IP in-house and then asserting it. So it's not people who are acquiring the IP. What we saw there was a strong difference in the business behaviors of the litigation PAEs and the wireless manufacturers. And when we're talking about wireless manufacturers, here we can tell you that we saw about, the manufacturers in the study represent about 90% of the worldwide market in that space. And we saw very different behavior. The litigation PAEs are, as we've said, litigating in order to generate revenue. The wireless manufacturers were engaged in licensing. Their licenses were, I would say, more complex if you look at terms of cross-licensing and other provisions, running royalties versus lump sum settlements. So you see this behavior, you do see a difference between the litigation PAEs in our study and the wireless manufacturers. So what do you do with this information? On the one hand, I think the study is very valuable because, as Commissioner Olhausen mentioned, before we conducted this study, if you weren't looking at publicly available litigation data, you were dealing with anecdotes. And you were hearing anecdotes in terms of, massive demand letter campaigns or other behavior. And we talk about some of this potential behavior in our 2011 report in terms of business models. So you have anecdotal information. Now you have a case study that presents information across a wide range of PAEs based on information that we've actually seen and that we've actually reported on. We do have confidentiality obligations, so we did our best to report as much data as possible in the aggregate and the best form possible. And this is where I really need to give credit to my colleagues in the Bureau of Economics. This was a joint project at the staff level between the Office of Policy Planning and the Bureau of Economics. That was a different way for us to conduct IP research. When we've done our other IP workshops, we've always worked with one or two economists, but here it was really a joint team. And I think that represents a new way of looking at data and a new way of being able to present information to the public. So finally, just coming to the recommendations, what we saw on the litigation PAE side was a focus on early stage litigation. So based on that, we propose recommendations that address the early stage component of litigation, right? We look to others. It's not just us. The Federal Judicial Center has noticed the potential for cost asymmetries in what they call NPE litigation. So we say that courts, Congress, whomever, should be addressing these discovery cost imbalances. We saw that there are networks of controlling PAEs and affiliates where that information would not be publicly available. So you see financial information running in a way that wouldn't be clear from the public perspective. We saw that the Northern District of California and the Eastern District of Texas have one way of looking at financial relationships when it comes to really focusing on judges and their decision of whether or not to recuse themselves. So we make a recommendation based on that, going to Rule 7.1. As Commissioner Olhausen said, we talk about streamlining multiple cases, looking at the party that has the best information. And then this report was entirely done under Form 18. So back when you could essentially say, I have a patent, you infringe, and that satisfied your motion to dismiss requirements. That world has changed. We wanted to recognize that. So we say that as courts continue to develop patent issues under Twombly and Iqbal, that they should be focusing on the notice in terms of the causation and in terms of the claims. So that's a quick overview of what we've done, and I'm really looking forward to the panel today. Thank you very much.
Thank you, Suzanne. Our next speaker is Fritz Scheuren, who's a senior fellow and vice president at NORC at the University of Chicago. Actually, when I saw that Fritz had done some work in this area and invited him to be on this panel, I realized that actually I knew him from like a long time ago. That when I was working on a consulting project a long time ago, and I needed some help on survey statistics. I asked a friend of mine at the GW Statistics Department if he knew somebody, and he recommended Fritz, who was a great asset. Fritz has had a lot of high-level positions in statistical agencies in the government and elsewhere, and it's a pleasure to welcome him here. Actually, I got to get your thing set up here.
You got to set that up.
This is it.
Thank you. Second, yeah, please sit down. Thank you. Hi, everybody. I'm quite interested in this topic. I've been looking at it more recently, and I listened today to the commissioner and to as first speaker, and I'll listen to the rest of the speakers as well, as I hope all of you are too, and maybe we can talk a little bit. I've been around for a while. I'm not looking at today, I hope, but I am. I have a lot of statistical background, and my focus will be on the statistics at different agencies, including the Census Bureau. And can you see that? I wonder if you can see those slides. There is a handout that was given outside that has more detail. I'm going to talk about two issues briefly. There was much more to say, of course. What about the statistical methods, and then a little bit about the nature of the results. First comment is that I think it's already said, but let me just emphasize it, that this is just an exploratory and not a confirmatory study. You can't jump from this study results to litigation, legislation, and so on. You have to do something more. And maybe you want to do it anyway, but you have to do something more if you want to be within the world of statistics. So it's exploratory. What does that mean? Broadly speaking, there are some points here. These are in the handout. This is what it means to be exploratory. You don't have to be able to prove anything. You just have to have a hunch. You don't have to be doing it with any basis at all except a hunch. Confirmatory, which is the more useful result, if you found something, okay, then you need to confirm it. And that means you have to do something rigorous, very statistical, hypothesis testing, all that jazz, in order for you to be able to defend what you've done. And if you've learned something that works for you, you then may take action. That's the step That's the paradigm for a statistician. What about the highlights from the FTC study, which were quite ably, only really, I would argue, exploratory and not confirmatory? That's what was said, and by them, and I'm putting my terminology to it. So what are the highlights? What can we learn from the highlights? That it's not designed to serve as a basis for policy recommendation. Not yet. Maybe more study, but not yet. And there are a lot of issues around it that that need to be advanced and examined further before one does that. That is, that the study itself had some narrowness to it, focused on a good issue, but a narrow issue, and more needs to be done. Policy recommendations are non sequiturs. The policy recommendations that are given, the 4 of them, are not really linked to the study directly. They connect to the study, but not in a connection in a cause and effect relationship. They're useful. Recommendations are useful as a way of studying the results of the study, but they're not by themselves connected. The FTC made 4 policy recommendations. That's been discussed. The word number 4 is not mentioned, but now it will be. And the study used results I think the study may have used results in a way that are contrary to what the study was designed to do. But maybe that's just exploratory, another way of exploring the consequences in a what-if way, not necessarily in a confirmatory way. And they don't logically follow the exploratory results and the hypotheses that or recommendations that are made don't logically follow. They're useful, loosely connected, but they don't follow directly. So bottom line, the study should not serve as a basis for litigation, regulation, or law enforcement initiatives by itself. But it could be, and I will recommend, again, a starting point for more definitive work. What about the absence of findings of important topics? Well, there were. You can't do everything in one study. Some of the ones that weren't fully dealt with was the full discussion of harms and benefits of PAE activity. There was discussed but not fully acted on, and no effect on recent patent reform. This, of course, the study was limited and finished a couple of years ago. The data was some of the recent stuff wasn't mentioned. That's been nicely covered by the first speaker, but they aren't statistically connected. No findings that PAEs are engaging in nuisance lawsuits. That might be happening, but it wasn't something that was done. What about afterthoughts? These are mostly mine. I've introduced the Japanese word kaizen, continuous improvement initiatives. This is one of the things that I think is underlying the work that's being done. That there is an attempt with this litigation, this study, and other things that are happening to make changes, to make improvements continuously, and make them better. That's the Kaizen comment. What are these afterthoughts that I have? Well, they're limited. Maybe we'll get to more of them in discussion. The first thing I think that we need to be sure is that the respondents, maybe this has been done, have been thanked and been given a copy of the study, okay, and asked to comment on it. Not in an OMB mandated way, but because then you have to have another issue, but in just as a sign of respect. That must have happened, but I just mentioned it. And of course, there is a need for further study. I have some other comments about that, but I think I'm done right now. Thank you.
Thanks, Fritz. Our next speaker is Josh Reich. Josh is the university professor at the Scalia Law School at George Mason and an executive director of the Global Antitrust Institute, and also holds a courtesy appointment in the Department of Economics at George Mason. He is a former commissioner of the FTC and was there when this study was started. So, Josh.
Thank you, and thanks for having me. In my old job, whenever I started these talks, I had to do the disclaimer and say you have to hold everything I say against me and not my colleagues. I sort of don't have to do that now, but I voted for this thing, so I feel like I have to give a halfway disclaimer. So you can hold half of my remarks against me. So let me offer sort of a couple of thoughts from a sort of different perspective, maybe from the two panelists that have spoken so far and from Commissioner Olhausen's remarks in the morning, which I thought excellently reviewed the findings of the study. So let me begin with, I think, a couple of things that are clear from the study, or I think that the study sort of takes off the table, and that's fantastic. One, if we go back to, and Suzanne started with this earlier, sort of what the swirl of issues was around PAEs, or sort of circa 2013 or 14. A lot of this was, is this a competition issue? Should the FTC be using the antitrust laws to deal with some of this? And I think one of the sort of themes in the report, and something that Commissioner Olhausen mentioned in her earlier remarks, was nothing in here to support that view, and we sort of shifted over into just talking about whether procedural or litigation reform and which ones, and patent reform as the policy instruments of interest. 3 years ago, that was sort of not a done deal as a policy issue, and so data has helped make progress on that, and for that reason alone, I think the study is a success. I have a paper that I wrote with Judge Ginsburg on the DC Circuit a couple years ago that said, hey, let's not use competition instruments for this stuff. This is a procedural or litigation issue, and requires procedural litigation fixes. So at least with respect to those findings, are consistent with my priors, and I guess that makes me happy too. Third, one of the things that I think is clear is that this is an excellent use of the FTC's 6B authority. I am a big believer in authority. I voted for the study. I like data, even when it's not the FTC's. This is sort of all good stuff. Now, one of the reasons, I have to say something negative, it's in my job description. One of the reasons that I voted for the study was in part the FTC's sort of open and frank acknowledgement, and it appears sort of in the Paperwork Reduction Act stuff, it appears in the study itself. The study will not extrapolate its findings to the population of all PAEs. The FTC will not project its findings to the populations of PAEs as a whole. Representations made to OIRA in this process, representations made to, say, commissioners who voted for the study, and former commissioners who once voted on the study. I think if you were to cut this report off and excise from it the policy recommendations, so my new job, I get to grade people. A plus, this is good stuff. It is good descriptive data, sort of as promised. Lots of it, I think, leads to avenues for future research where we can sort of think harder about causal inference and sort of things economists care about identifying effects before we get to sort of policy prescriptions. But we didn't do that. Instead, we extrapolated to the population of PAEs. I don't know how one makes a policy recommendation that applies to the population, even beyond PAEs, the population of, say, patents, or the population of litigation, right? We've got things where we want to modify federal rules of civil procedure, right? That's problematic to me at a sort of general level. The descriptive stuff, I think, A or A plus, but we go and we say, we're not going to extrapolate, but on page 14 of the study, we say, based on what we did, I've got policy recommendations. That, I think, is a tension that's unavoidable and difficult, and I think sort of for whatever value in the study in the descriptive data, and I would concede a lot. There's a lot of value in the descriptive data. To me, that approach in FTC reports and recommendations is problematic. Said so when I was commissioner. I've got a couple dissents on reports where I think what we did was either not do any data analysis at all and then make recommendations. We're much better than that here. It is just that I think the recommendations, let me sort of be clear, may be good, may be bad. I don't have any sort of, at least here today, no sort of bone to pick with any of the specific recommendations. Some of them might make the world better off. Some of them may make the world worse off. I don't know, and I don't think that the data allow us to distinguish which recommendations would do what. And I think for the FTC, as the expert agency, our sort of standard of care on this stuff's a little higher. Right? To me, and your mileage may vary, but to me, the standard of care for the FTC should be something like the following. Is the policy recommendation that we are making, would it survive a cost-benefit test? I don't think the data here allow you to answer that question. May well be that the answer is yes, just that the data here don't allow you to answer to the question. So if I were to walk through, and I'll do this sort of quickly, but if I were to walk through the individual recommendations, easing the discovery burden, right? So the FTC has some evidence that success in achieving settlements rises from asymmetric costs. 77% of the settlements come in under $300,000, consistent with some nuisance litigation happening. And so the FTC says, hey, let's amend Rule 26 to deal with some of this. We've got high mark and octane fitness sort of coming afterwards. I don't know whether the cost of implementing the proposal, I can imagine the benefits. I don't know whether the proposal passes sort of cost-benefit muster, even with sort of a relatively light data touch. So to me, I think not sort of necessarily over the bar. And one sort of note, the recommendation clearly requires us to extrapolate beyond the sample into the population. Increased disclosure of related entities. So this is Federal Rule 7.1. That rule is meant to help judges identify conflicts for recusal purposes. I don't know if there's any evidence that that's been a problem in any case involving a PAE. Let's sort of put this in cost-benefit language. So the expected benefit might be zero, or might be very low. Again, if I wanted evidence to shed light on this question, that's something I would want to know, right? The purpose of the federal rule, I may have some other benefits, but again, not that we can use sort of from, that we can answer from these data. Same with the stay on parallel litigation. Maybe a good idea, sort of maybe not. I don't know, and I can't answer it from the report. Again, not a criticism of the data that's in the report. What is in there is well done. It is important. This is an area where I think we were, and I fully agree with Suzanne's earlier characterization, you either had sample selection plagued litigation data or you had stories to tell. This is better. This is much better. And so again, that part of the report, A+. The rest of it, I think, something less than an A+ that I will keep to myself. Developing pleading standards as sort of the fourth. This one I find more curious than anything else. So the FTC recommends that courts develop case law regarding the Twombly standard. I don't know what else they would do. It's the law. I mean, this is what they do, is develop case laws applying the pleading standard. So I don't necessarily have a beef with that. I don't know what it does. And I don't think it has anything to do with the data in the report. So I will sort of end with that, or at least what I think is a worthwhile thought experiment for those who come to sort of data questions from a place that's different than an economist or a statistician. I like to think about these things, sort of, Fritz gave the statistical framework. I like to think about these things like an economist. Would the recommendations pass the cost-benefit test? I don't think we've got enough to answer that question, and my preferred course in those cases would be don't give policy recommendations until you do. I think that's sort of a threshold standard. But for those who think about it slightly differently, and maybe my sort of years in the commission have sort of adjusted my framing to thinking about data in ways I will only recover from in a couple of years.
If ever.
If ever. But if the policy recommendations came to the FTC, to our Bureau of Consumer Protection, and the policy recommendations, the implicit or the express claim was something like, these policy recommendations will make the world better off, or their benefits exceed their costs, and we offered up the study as substantiation for the claim, I would not want to be defending that thing in front of our FTC. Again, I want to be very clear. I think there's a ton of great work done here. I think this is the sort of report the FTC, if you asked me to vote again, I would say I would vote for it again, and I would try to extract some extra promises about not writing policy recommendation stuff, but I'd vote for it again. I'd vote for it, every single time. But I think it is important in large part because I think there's a little bit of a trend here in terms of offering recommendations untethered to data and analysis sufficient to substantiate them. We have got some of the best economists in the country, in the Bureau of Economics. We've got some of the best competition and consumer lawyers in the country inside the agency. We can do reports that meet that standard. And we can be disciplined enough to refrain from policy recommendations when the data just don't allow us to do that. And so I think that is, while there's lots of interesting things to talk about, I think that's at least one issue to flag, and I will stop there.
Thanks, Josh. Our final speaker is Rosemary Zadanis, who is a professor at the BU Business School, the Questrom Business School at Boston University, and has done a lot of work on intellectual property issues, and it's a pleasure to have you here, Rosemary.
Thank you. Great. So a couple of things, just so that you know where I'm coming from. I really enjoyed reading this report. It was a flashback to a lot of testimony and work that I had done. I see Steve Merrill in the back of the room with the STEP Board and the National Academy of Science with those early reports from the early 2000s, and then the Federal Trade Commission and the Department of Justice following in the wake of that in 2003, around that era. So before I go into comments on the report itself, I'd just like to share a couple of perspectives from that early era that seem salient. So the reason I was involved in that then was a study that I had done with Bronwyn Hall on the semiconductor industry. We interviewed and then did quantitative analysis on what we would now call non-practicing entities. At the time, we just called them fabless firms. Now we have other types of specialized companies in that space. We also had large manufacturing organizations such as Intel, such as AMD, that at the time, many of our semiconductor manufacturers actually were manufacturing in the US. Now we're down to one or two. They, as is well known, played the big portfolios of patents, cross-licensing in the shadow of litigation and countersuit. So a couple of findings coming out from our study of what is the role of patent rights, and at that time, the strengthening of patent rights, the shift with the Federal Circuit Court during the 1980s. How is that really affecting innovative activity in that industry? We had two findings, and this report still is wrestling with these types of issues. One is ex ante. We found compelling evidence that those patent rights are really important for entrepreneurs and venture capital-backed companies that are investing non-trivial amounts in those companies, most of which are going to fail, right? Lots of expensive experimentation. The promise of those patent rights being able to enforce those rights or even to sell those rights to another party in the event that your bet actually failed was pulling in investment in those companies. Okay, so that's one of these nice ex-ante efficiency type of effects. The flip side of we're going to have stiffer penalties and more enforceable rights at that time was that our large manufacturing firms were concerned about holdup. The royalty stacking that the commissioner had responded to, had alluded to earlier. It was interesting in reading this report that these concerns about after the fact, now that I've spent billions of dollars in the ground, I'm negotiating with so many of these rights holders out there. So these thickets problems, it was actually interesting, and I'm sure this was not an accident, that framing of the policy debate in terms of thickets industries, just the explosion of rights and the complex kind of bargaining challenges that are out there, the language actually wasn't used in this report. So one of the things that we found is that, yes, after the fact, that it looked like these companies were really investing in almost self-insurance. We're going to patent a lot more because we need to protect ourselves in the event that we're in one of those lawsuits or in one of these license negotiations. So one of the findings from our report on one industry, so this is the Rand Journal of Economics, it's now an old study, 2001, was that even just looking at that industry, the ex-ante versus these ex-post trade-offs are complicated to sort out. And in fact, maybe a little bit of both was actually going on. Now, this report is still wrestling with how do we weigh this stimulus to innovation with these ex-post licensing and litigation behavior, except we're taking that in the context of one particular organizational form, and that is patent assertion entities. So the great thing about this report is that we now know a lot more about patent assertion entities than we did prior to this careful work that has been done. So that is an important contribution in the spirit of evidence-based policymaking. The main weakness is that even learning what we have learned, it's still premature. We can't answer the fundamental question based on the evidence that we have in this study alone as to whether these ex-post lawsuits, whether we call them nuisance suits, which I think is important to flag as a question, not being answered by this report, outweigh some of those ex-ante incentives that entrepreneurs and investors and even corporations that are making costly investments in R&D projects, many of those projects fail, and these organizations are serving a role as intermediaries in that market for patents, not just markets for technology, but this is just the resale value in the event of these mini experiments that fail. So I don't think that we can conclude on net, based on this evidence, kind of where we stand in terms of the role of PAEs, but we have some really important clues that we didn't have beforehand. So some of the strengths in the report. One is we are clearly taking, I think, a very laudable step away from the troll terminology. That obscured lots of debate, in part because it's just a normative laden, value-laden term. So you will see that they acknowledge that term, but then are very careful with their language with these patent assertion entities. They're telling us that, yeah, there are different business models out there, but they're highlighting two very distinct ways of doing business among these portfolio PAEs that when I read this report, I'm thinking just like with cross-licensing in other contexts. These are large portfolios based in part on the efficiency that you have. If you have a large portfolio where you have bundled those assets, it is easier to strike a license before going to all the way without having to litigate beforehand, as the report, I think, makes clear. We see that there are the portfolio and then the licensing, different, litigation types of models. Other, in terms of the insights that are coming out of this, I was actually blown away. I had no idea that starting out with 27 responding patent assertion entities leads to 327 affiliates that are asserting the IP, and then we have 2,189 holding entities. So that is astounding to me, to see that there are so many of these affiliated entities. I think that the report, I actually agree that it is premature to reach a conclusion based on the evidence as to whether that is per se problematic or not. The report actually lists some fairly plausible efficiency reasons why the litigation PAEs may actually have that type of an organization structure. Then there are some other explanations, other factors that are buried in the report that also suggest that could be problematic, especially when we're thinking about the role as intermediaries in a market. Typically, we like to think about transparency in those markets, so I'm sympathetic to that as an argument. The final strength, two other strengths that I'd like to point out. One that I haven't heard the others comment on, but I would just like to underscore, this is a well-written synthesis. There was a lot of careful work that has gone on behind the scenes in distilling what do we know from other studies to date, not just stopping there, but mapping it to, much like the commissioner's response. The world has changed a lot since 2014, and they don't just stop their report at that. They're actually giving us some insights as to what are those key developments, both administratively with the FTC and the cases that you guys have settled. At the Patent Office, we see action there, and with legislation, and especially important, the courts. And on that last point, I think clearly it is premature to rush to policy recommendations, given especially the importance of some of those court rulings, Octane and others, that you guys rightly point out in the report. So the main disappointment that I had, I guess two disappointments. One is I too would have voted to have let this report be evidence-based without forcing you to make those policy recommendations. I think that is one of the weakest links in the report. I can understand why you did, but again, that's the relative to some of those important strengths. That's the weakest. So just focusing on the nuisance value conclusion. That one is the $300,000 average settlement or median settlement value for the litigation PAEs sufficient evidence to suggest that that's nuisance value? Maybe, maybe not. We absolutely can't conclude from that alone that those were frivolous or non-merit-based lawsuits. The other on that point that I haven't seen get much attention, at least in the press thus far, and it hasn't come up, so I'd just like to point this out, is you actually have some evidence in the report, but it's buried. It's on page 140 that suggests, hey, wait a minute, maybe these aren't just lawsuits of dubious value, and that if we believe that citations, there's an if there, this isn't a perfect measure of value, but many economists correlate citations with economic value of patent. It's not perfect, but there's a correlation out there. There on page 140, we're told that the litigation PAE patents have a median cite of 14. That is, again, my statistician is not going to probably, so Fritz is going to knock this one down from the statistical perspective, but still I think there's a qualitative jump here. The median citation rate for the portfolio PAEs controlling for vintage and other types of obvious factors is half of that, which is 6. And then if we took a draw from the broader distribution, it's much smaller than that. So I think that evidence jumps out at me as to saying, whoa, we really can't rush to a conclusion here based on those facts that this is necessarily a nuisance situation. The final thing, so I previewed some old studies that I had done in the semiconductor industry. I would just like to say that I hope that a lot of the work that has gone on into this report, you now have more information about the identities of these patent assertion entities and the holding companies. It's really hard for researchers to piece that together. So my colleague Carlos Serrano, who's done a lot of work on markets for patents, he and I have teamed up. We have a new study that I'd be happy to share with you guys when it is actually written. We have the results and are in the process of writing up this study this fall. But we've looked at all venture capital-backed startups in the semiconductor, software, and medical device industries. We take the ones that have patents and fail, right? So this is not a tech transfer issue. This is just a salvage value of do we resell those patents? The time frame was up until 2012, so capturing companies that were founded from the 1980s through 2012. So clearly that's important. This is not the most recent time period. But our evidence to date suggests that this resale market for patents is much more liquid for those companies than is typically characterized in the press. So of those firms, 80% of all of their patents find buyers, and they're sold pretty quickly, within a year of the disbandment of those companies. So one of the things that we are wanting to do, we have thus far, so to the point, a question was raised about buyer power in these markets. Our preliminary evidence is suggesting that it is far more common for those patents to find their way to corporate buyers, which means that if we're thinking about competition in the patent market, we can't just look at patent assertion entities as being the only buyers in that market. It is hard, again, to know which of those buyers are actually patent assertion entities. Our way of using Dave Schwartz and Jay Kassan and the numbers, the names that they have publicly released, is that patent assertion entities are playing a non-trivial role in that market for patents, buying these assets from not for tech transfer purposes, but these are bets that venture capitalists and entrepreneurs were placing under great uncertainty, and many of those companies and many of those bets fail, and yet one of the wonderful things about patents as an asset is that you can actually have a resale market, and others may be willing to pay, which ex-ante efficiency, that's calculated in terms of expectations of the value that you're able to capture from those those investments. So in sum, I think there's a careful, well-written synthesis. It provides evidence on demand letters, on licensing revenues that mere mortals, such as myself, can't ever see. Right? That is a huge contribution of this study. It stops short with the policy recommendations in terms of, I think that there is just a disconnect in terms of the evidence versus the recommendations, as we've already mentioned. And to me, one of the things that I'm particularly excited about is that I do think that it is a solid stepping stone and points us in really important directions for future research, which is an accomplishment in itself. So thank you.
Thank you. Let me, I don't know if you want to, let me ask you
Yeah,
a question
yeah,
and
sure.
you can respond. I mean, as obviously you're aware by now that the most common criticism of the study is that the recommendations don't really follow from the study.
Everyone has said that, yes.
Several people here and people on other panels, and it's partly for the statistical reasons, but I think it's also for even if the statistical problems weren't there, I think people think that just logically the recommendations don't necessarily, and I think people, as Josh was saying, if you wanted to really look at the recommendations, you should do some sort of a cost-benefit analysis of the recommendations themselves.
Yes.
So, do you want to talk about that?
No, I'd love to. I think this is a really thoughtful point that people have been raising. I'm grateful for all of the sort of positives and negatives that were raised on the panel, because I do think, as several of you have mentioned, this is one of the first studies of this kind. When we were talking about it initially, we talked a lot about a black box. You didn't know what was happening with these PAEs, you didn't know what was going on, and you had a lot of policy work, as Commissioner Olhausen mentioned. If you go back and look at all of those bills were being based on, various types of information, but nothing like this report, right? So you want to think about that. Secondly, in terms of, what we told OMB and what OMB asked us, what they said was, where possible, the Federal Trade Commission should note the limitations of the study, and in particular note where and why the results of the collection may not be generalizable in any final reports, recommendations, and/or presentations that the Commission produces based on the study. So OMB did consider that there could be recommendations coming out of the study. Moving to the statistical point, I absolutely appreciate everything that you've said. Another path that I could have gone down in life was to get a PhD in statistics. I came pretty close. I did this instead. So while we can't definitely tell you that a fraction of PAEs operating in the U.S. are of these two types, right? And that's because there is no universe from which you could draw a statistical analysis. So when you're faced with that situation, what do? Do you say, there's no universe out there, the information doesn't exist, I'm gonna just go home, focus on something else? Or I'm gonna do the best I can, I'm gonna present a case study, and I'm gonna present a case study where I think we can say we are confident that these two types exist, litigation PAEs and portfolio PAEs, and that these two types of firms account for an important fraction of PAE behavior. As we've mentioned, the PAEs in the study held approximately 75% of patents held by US PAEs, and the PAEs in the study initiated between 14 and 46% of all PAE infringement litigation during the sample period. So that is, addressing the case study point. Now, moving to the recommendations point. What we saw was striking in terms of litigation PAE behavior. We saw the high 90% of litigation PAE licenses following litigation, right? So it's not a few litigation PAE licenses followed litigation. It's in the high 90s. Similarly, when you look to third-party analysis and you see that 70% of your licenses, the litigation PAE licenses, are below $300,000, you have to start asking yourself some questions. What does that mean? And that's where we draw on the AIPLA data, where they're saying that that is sort of a lower bound of discovery costs. So then our recommendations go to what we saw. This is important, and this is something I think that we have addressed a little bit on this panel. We saw these particular, I think, strong behaviors in terms of litigation PAEs. We saw behavior that focused on early stage litigation. I'm a former patent litigator. Those of you who have litigated understand discovery costs and how discovery works. So the Rule 26 recommendations, first of all, they're to courts and to Congress. We're not saying you need to do this. They're really pretty, I think, broad. Secondly, we're saying where somebody has the information, that information should be shared, right? This is everything we're saying in Rule 26 is information that could be collected, but it's information that's collected after extensive discovery costs. So, I think Josh and I would come out differently on the cost-benefit analysis. That probably doesn't surprise you. But you need to consider what we were trying to do here, right? So we're saying that those who have the information should share it. Same thing with the Rule 7.1 recommendation. That's something that already exists, so it wasn't something that we created. But you're looking at a situation where we observed a number of shell companies within our case study, and you think, well, how have people addressed this? One is this Rule 7.1 idea that maybe you should have broader financial disclosures. Maybe there are other ways to get the shell company information into the public. Because as Rosemary said, we looked at data here that only the FTC can look at, right? And we've presented to you what we can, but we actually know a lot more. But maybe other people should be able to collect that. Maybe if you have these Rule 7.1 disclosures, Rosemary and her colleagues could pull that information and tell us more about what's going on, right? So then you move into the customer stay provisions, right? Again, this is something that's been supported throughout patent reform. We saw a significant percentage of patents in the ICT sector, right? But we saw those patents being asserted against folks in retail trade and other sectors. So then it's natural to ask, if you're suing the manufacturer and the customer, what's the best way to handle that, right? And we say that we encourage courts to think about this. Congress should think about this, right? Congress should think about whether you have parallel suits where one party has significantly more information and whether that's good for judicial resources, whether those costs are beneficial. Finally, listen, I think patent notice is important, right? Maybe we could have done this without the Twombly-Iqbal recommendation. But having focused on patent reform, patent issues, the intersection of antitrust and intellectual property for, almost 10 years at the FTC, patent notice is really important. And so encouraging courts as they're developing Twombly and Iqbal to keep in mind the role that notice plays when you may have, as Commissioner Olhausen mentioned, you may have people who are copying, but you may have inadvertent infringement. And if you have inadvertent infringement, it's helpful to know why I infringe, what's going on, what are you actually accusing me of? And to me, what's important with all of our recommendations is none of them get in the way of meritorious patent suits. Providing more information in Rule 26 doesn't say, look at these guys skeptically, right? Providing more information about your financial relationships doesn't say, look at these guys skeptically. Figuring out which court should be addressing litigation. It's all within the range of protecting the patent system. So obviously I come down differently on the cost-benefit analysis than others, but that's how we get there.
If you just,
Yeah.
if you change the balance of costs,
Right.
you may deter what you call nuisance suits, but you may also deter meritorious suits.
So that's what's interesting. People have raised this. If I have information and the burden is now that I provide more information that I already have, I'm interested in understanding how that, because this is a point people have raised, right? I think it's something that we should be thinking about. And the other message I want to give here is that this is something we should all be thinking about, right?
It's
We're
just
not coming down on
because
it.
it's easier for people to defend against it. It's less costly to defend, so.
So well, it's more
regardless
about if I'm the plaintiff and I have certain information, right? Should we be thinking about whether that's information that benefits society for me to present to the court, or whether it's information that I should hold and it won't be presented until you take a number of depositions? So that's how I think about it, and that's the question you really have to ask, how that works out, and whether the type of information that we're saying should be disclosed as part of Rule 26 is that kind of information.
I have two clarification questions, and then I'll throw it open to everyone else. The report talks mainly about these recommendations in terms of PAEs, but it's a little unclear to me whether, in fact, they would just, whether they would apply to everyone, all patent litigation,
Yeah.
and if they wouldn't, how you actually would define, I mean,
That's a good question, whether the recommendations go to all patent litigation or just PAEs. The recommendations in this report are meant to address the litigation PAE behavior that we observed. So that's why we talk about PAE litigation there. We're really trying to focus on what are recommendations that would address the behavior that we observed. So it's limited to the folks that ran the case study.
the second question, this is, when I read the report, this stuff about the citation data that Rosemary, it also jumped out on me because part of the kind of the quote patent troll narrative is that there's a lot of low quality patents, and that seems to conflict with that. Do you want people to come away from this report saying that, well, maybe there really is no difference in the quality between?
Yeah, no, quality is such a tricky consideration because you don't actually know the quality definitively until it's been litigated, right? And so we have 37,000 patents, something like 37,000 patents in the study. And to really get at those thorny quality questions, you would have to have a mock trial on each of them, right? I mean, this goes to points that the commissioner raised with respect to portfolio licensing. This gets into a lot of really interesting areas in terms of how the patent system works and whether it's working as efficiently as possible. But so what we did was to look at what we thought were reasonable metrics that others have used to address quality. But personally, I think that there's a lot more that goes into the quality analysis.
Does anybody else on the panel want to comment?
I'd like to,
before?
Thank you. I hope you understood that I really like this report, okay? I do. Well done. Everyone said that. The disconnect between the report and the recommendations is the focus of everyone's comments, right? I live in a world most of the time where I do modeling, tax modeling, in income tax transfer systems, okay? And where you do develop micro-simulation models. And this would be a result of one iteration from this wonderful database that you've developed. And you should be doing more micro-simulation models, tax transfer in my world or in this world here, where you look at this, what-if discussions of all kinds. And that's really the value of the database, because you really haven't really analyzed much data, being presented anyway, all right? There's a huge amount of data you collected, and you've done very little with it. That's my main criticism. And the way around that, given all the privacy and other issues that you have, the main way around that is to build micro-simulation models, which is what we do in the tax system, okay? All of us, and in the transfer system too. And I recommend you do that. And there are lots of good models to do that. And you maybe have already thought about it, you just didn't talk about it.
A couple of sort of small responses. One sort of small point of clarification. I think Suzanne said a couple of times that we would come out, like we come out differently on the cost-benefit. I have no position on a cost-benefit analysis other than there should be one. I don't know how we could come out differently because there's not one. But my position is solely that there is one, and then where I would come out would depend on the cost-benefit analysis. You have to do the cost-benefit analysis to know what's in it. And so that would sort of dictate where I would come out, but I'm sort of fully open to the idea that there could be litigation reform sort of movements that would shift welfare in one direction or another. There's in fact large literatures on this in other settings, in sort of economics of civil litigation literature, where people go out and they get identification and they measure stuff and sort of say sensible things about welfare. And I would look forward to reading something like that. I do agree with the proposition that the descriptive data in the report, as Suzanne says, makes it natural to ask a lot of questions. I totally agree. I think that what we should do when it is natural to ask questions is ask them, and then go get the data in the next study to answer them. It would also be natural to say, we've got some descriptive data. It raises these questions. It raises the question of whether adjusting Rule 7.1 would be good or bad, adjusting Rule 26, or having a stay on end user actions. It raises those questions, and in further study, ... back to A+ territory in terms of the grading, I think. I will sort of leave it as an exercise to the readers in the room, but that is not what the recommendations say. They don't say, let's think about it and it's natural to ask. They say, courts should do. In large part, they say that. So, as between, I think there's a sort of a fundamental disconnect on what the standard of care is for an expert agency making policy recommendations. One thing you can do is move the standard of care and say, this is the best we can do with the data. And I have sympathy for that position. And I think that there is, I think certainly for an agency in the FTC's position, you don't want to be stuck in a position where you say the data's imperfect, I've got nothing to say. But I think there are lots of things you can say and still be faithful to the standard of care. I get nervous when the argument is, let's move the standard of care in a downward direction so that we can make policy recommendations, because these are really important. I tend to think about it the other way. When the welfare consequences of a policy issue are really important is exactly when you need to keep the standard of care where it is, because the stakes are high. So whether OMB says we could or should, there's lots of things we can do that maybe we shouldn't. And I think one of them is sort of move the standard of care around to be able to participate in a policy debate that is very attractive, and lots of people are looking to the agency and wanting them to say something, and that is a sort of big, powerful pull. But I think there are things we could have said, like it is natural to ask these questions. Let's go do some more research, that we didn't do, and I think that would have been a preferred outcome for a variety of reasons. But also, sort of, let me end with saying, none of that should be taken as diminishing at all the value of the work that's there. Researchers are going to be very busy for a long time thinking about these things and writing about them. And I love everything that's in this report in terms of the method and the way that it's written, sort of except for the attention to the standard of care, which I think an expert agency has to be more attentive to than ever. So I'll stop at that.
So probably under the conditions of the study, the 6B study, these data are not available to anybody outside the FTC, right?
That's right.
But-
No, I'm sorry, go ahead.
But in the world that I'm in, the same problem, not available to data, but there's a microsimulation modeling, and people are able to do things and get information back on the models that they want. And therefore, the data is available only with you, but the analyses are shared, okay? And results can be made public. And then you can get the kind of debate that moves from the recommendations, which are just one example of that outcome, to many other examples. And the weakness is that it's just one example. It's not that we've now explored this enormous amount of data. You have collected an enormous amount of data. Very good data, too, as I can understand it.
I think just one point on that, which was surprising to me. When we started this report, people asked, is this behavior the tip of the iceberg, right? Are there folks sending out mass demand letters that you wouldn't see crossing the litigation threshold? Now, we explained in the report why there are reasons why we might not capture that behavior here, but that we're also paying attention to it because of MPHJ. But I think there is additional work that can be done based on publicly available litigation data that would provide some interesting results.
And I mean, a hidden value of the study to that point is, whether an outside researcher can get their hands on the data or not, I think it raises interesting research questions that people wouldn't have thought of
Right.
before, and they can go get their own identification and their own different data
Right.
and approach in different ways. I do think there's a lot there, but that's what a descriptive report does, is it describes the distribution that's out there in the world and causes people to go out and think and then find causal inference and make policy recommendations. And, I think there's a step 2 that's in there somewhere.
There's a need to iterate the data. You have wonderful data. Very little bit of it has been displayed so far. Okay.
So let me
and
open
needs to be.
it up to the audience. Could you, yeah.
Thank you. So one of my questions for this panel is, to whom do you think, what audience should the commission have addressed this report? As you know, as I looked at it, you know, knowing sort of the fuller context, the number of bills and proposals that were being put forward, and even some of the recommendations in the report that the FTC had actually already made unanimously in February 2013 to have real party and interest improvements. I thought some of the value of these recommendations was really to remind policymakers, which is Congress, who may not wait another 4 or 5 years for yet another study, to the extent the issues, the differences that we saw, the behaviors that we saw occurring, which had driven sort of this frenzy of responses that I already talked about, to remind them of tools that were already in place, the ability of courts to stay, that Twombly now was having an effect, that we had already recommended real party and interest. So I guess my question is, if you don't think we should have addressed that, do you see any concerns about the report's data being, I would say, either overlooked or other people saying, well, this supports, we should have bonds and we should have, all the different things that were in those bills. So I think that's my question. It's a pragmatic matter in the Washington process of how laws get made and how policy actually happens. Sort of the counterfactual, if there were no recommendations in this report, do you have any concerns about the fact that other conclusions may have been drawn without the FTC's voice?
I have some thoughts. I sympathize with the pragmatic dilemma, to be sure. And I think whether the FTC says something about policy recommendations or not, there will be lots of voices saying lots of things. That there's a market in using reports to sort of folks' advantage, and I think that market operates regardless of whether we say things or not. And it's operated for all of our reports for all time. Sometimes we participate in that market, and sometimes we don't. But that is going to rage on sort of either which way. I don't think there will be less abuse or misuse of the data in any direction because we say something or don't. So that's my sort of response to that sort of that point. But the larger one in terms of the pragmatic sort of dilemma, hey, there's a policy debate raging and people are going to do something. I think it's okay to address. My position is certainly not we need to be silent about those issues. You can make a defense, I think, of some of these things that they don't require change. Others clearly do. I think the bar when doing a 6B is a little higher because we're going out and burdening people and getting data for us to then say, I use cost-benefit language, but whatever the bar on substantiation, I think is slightly higher than a, commissioners vote your priors on with whether you think this is a good idea. I think when we go out and we say our economists did this and we got 6B data and we're going to burden sort of people to get the data, when we make recommendations, I think we're signaling something about the link between the work and the recommendations. If the message is the one you described, that is, we're just reminding, that doesn't come across in the report, and I don't think the report's written that way. I would have preferred if it was. But further, even for this other bucket of recommendations that clearly require change, I think there are ways, for my 2 cents anyway, that you can have your cake and eat it too, in the sense that you can say, these are important issues, these are policy instruments that you have, let me remind you, you have them, but not make claims that changes make the world sort of better off without having substantiation. It probably weakens the message, and I think the political economy of that puts the agency in a tough spot. And people sort of weigh the benefits of having the FTC sort of speak on a hot issue where something's going to happen. We get to be relevant and so forth, and that's important to agency capital, and I understand. But to me, any benefit that arises from that there are few things that I think diminish capital in the way that playing around with the standard of care does for substantiating recommendations. I think reasonable minds can disagree over whether the report does that. I think it does, and some others think it does. But that's where I would come off on that trade-off. I think the way I would try to minimize the cost of not participating is by participating, but participating differently.
Can I respond just quickly as well? So I just wanted to say that many of the contributions, so if we're thinking about evidence-based policy, it doesn't all have to be, of course, in one report. So I would argue that some of your strongest contributions to the policy debate are about what you don't find, right? The dogs that didn't bark. And that's really important. Now, we don't need then the report to be making explicit, therefore we should do this and this in terms of our judicial process or whatever. That finding, those findings alone, such as the demand letters and the litigation PAEs, is an important contribution to the policy debate. On the academic side, for many of those debates, not all, but some of them are based on economists and legal scholars and others who are making inferences based on tip of the iceberg problems. So your report also lets academics understand that the severity with which we are looking at a very small tip of an iceberg if you are manufacturing organizations. Most of the activity isn't going to show up in our litigation data, according to this report. If you are a particular type of business model, litigation PAEs, you're probably going to have a much broader, deeper representation of economic activity and licensing and revenue flows as captured through the litigation data. That will feed into future research. That's a very important finding that doesn't require then a policy recommendation as part of the report. As an academic myself, I would put on the table that for future reports, probably the thing that I find a little, it feels like a shame to me that this quality of data have been collected. And I would love, like the census has, like we have other types of agreements where researchers can use blind versions of the data and come at it from different ways. So certainly for future reports that are costly to administer, costly to the community, I would love to see that structured so that it could facilitate other pairs of eyes, even if the identities are blinded, much to the point that Fritz was making. Thank you.
That's what I was trying to say too. Really, you've got this wonderful data set. It was one moment, well structured. I went through the whole process that you went with OMB, so I'm well aware of what was done. And yet, where's the results? That there has to be another step here, because you have all these protections that you have to guarantee, and that's the step that I think you just outlined, and you alluded to.
Well, I think they won't kick us out of the room if there's one or two questions, but if there are one or two questions, we'll try to take them. If not, sure. Let me just thank again the panel for a great discussion, and also thank Commissioner Olhausen for